Hi, everyone. Harry here to talk about James Comey's two motions to dismiss the indictment against him brought in the Eastern District of Virginia by ingenue U.S. Attorney Lindsay Halligan for allegedly making a false statement to Congress and in the process obstructing justice. Okay. For those of you who follow my Substack, I was really focused on this case from the start, and the week after did 5 different Substack entries, but one of them was on possible motions to dismiss. And indeed, these were the 2 that I selected. Just for quick information, a motion to dismiss says you can get rid of this case without even thinking about the evidence. It doesn't matter what the evidence is. Before you hear a word of it, there's a legal flaw that justifies dismissal. And he's done that twice. And the first one, the one that everyone saw coming and that seems a really strong candidate for dismissal, is that he's been vindictively or selectively prosecuted. I'll get to that vindictive or selective in just a minute. But this is the motion in which he lays out chapter and verse a chain of events that presents a stronger claim for having been prosecuted because Trump ordered it. And he ordered it for reasons of political payback and retribution that I've ever seen. So it actually goes to all the way back to Trump 1.0 and that dinner that Trump basically made him attend uncomfortably and the loyalty pledge he tried to exact, and goes all the way through a very vivid compendium of the different once Trump turns sour on him, he turns very sour and is trashing him right, left, and center, including, of course, firing him. And for good measure, when he fired him, Comey's out in California, he makes him fly back commercial, not take the FBI plane. But there's all kinds of criticism that Comey levels once he is in the private sector, and then testimony. It's very clear, and we always knew that Comey is very much on the enemies list. But then the final few days set up a very strong, I think like overwhelming case of what went on here. Remember, Trump basically ordered the acting U.S. attorney, Siebert, to prosecute Comey. Siebert said, I can't do it. It's not here. And he fires Siebert. So that's, a showing of both the illegitimacy of the prosecution, but also Trump's absolute determination to fire him. And he's, by the way, Trump never had any notion in all his public statements trashing Comey if he had done a particular crime. He professed kind of ignorance about that. But he said again and again, and including in this sort of what we thought might be, and turns out to be Exhibit A, email that he seems mistakenly to have published to Bondi that says, these guys, and he names a few, impeached me and indicted me. It's time for justice to be administered, and justice there obviously means payback for their antagonism or what Trump takes to be their opposition, and that really has Trump in a lather. And that's the only reason. And that is, in fact, a violation of the Constitution. Okay, so he sets it up in a very strong fashion. Oh, and then, of course, what happens? They fire Siebert. They bring in a woman handpicked for Trump who has no prosecutorial experience. She goes in a few days, indicts Comey, and Trump celebrates. It's all laid out very cleanly and very well in the statement of the motion. Then they move to the law. And I just want to note that these motions, as I've said repeatedly, are very hard to win. And so the case law tends to be only somewhat useful. But they also, there's a concept of selective prosecution, a concept of vindictive prosecution. Those are a little bit different. And Comey basically, and it only makes sense, tries to argue for both. But vindictive prosecution, which he leads with, is for a prosecution in retaliation for the exercise of constitutional rights. And what Comey is saying is because he spoke out First Amendment rights, that's the reason Trump hates him and went after him. There's also selective prosecution where you show this kind of prosecution or case is rarely brought. And the reason it was here was because of an improper motive, race, religion, and also personal revenge. And he speaks to that, but he also has a little bit of difficulty in the where he tries to say they rarely bring cases against people for this sort of crime. He points to 4 cases of higher officials who were not prosecuted, but it's such a rare sort of event, and you don't have a big sampling size. So I'm just trying to explain why I think he hedges a bit, and then he makes just 2 flat out constitutional arguments. It violates the due process clause to indict someone because the president has animus toward them. That's just true and established in the law. And then it's an equal protection violation to single out a defendant for the same improper reason. So we all know what the facts are, and he just wants to cover the waterfront and say, basically to Nachman off the judge, call it equal protection, call it due process, call it vindictive, call it selective. It's all here. Okay. The other big point to note in that motion is it ends by asking for discovery of the process by which the government arrived at an indictment decision. And that could be a really explosive kind of fight in and of itself as the government tries to say, oh, you can't touch this, it's executive privilege and the like. And Comey responds, executive privilege is just a partial privilege that yields when there's no other way to get the evidence. And we'll see what happens. Now, the first submission in his motion basically, says, I want documents that go into this. And so that includes what I've called Exhibit A, which needs to be received and in evidence for him to really make use of it. But he said, let's start with documents and an evidentiary hearing. So that evidentiary hearing would be quite a brouhaha. And I think the administration would resist it ardently, but I think Nachmanoff easily could hold this is legit and there's no other way to get it. And, here's the discovery, and maybe even call your witnesses, which might include Halligan, Bondi, and even Trump if there's no other way to get at some of the things he said. Okay, so motion to dismiss, and you do dismiss with prejudice if this happens, because it's done for political retribution. The 2 points to note is a little bit of covering all bases on the possible label to give this and therefore the possible case law to invoke. I think you'll see that as part of the argument when this is teed up before the judge. What category exactly are you talking, Mr. Comey? And then second, the request for discovery at the end. At the very least, we need discovery. And I think that the court might be inclined to give it rather than just dismiss outright. It could try to dismiss outright, just take sort of judicial notice of all this stuff there, or he could approve discovery, and I think doing it would prompt a big hissy fit from the government, and they might try to pull out stops to prevent it from happening, emergency, etc. But it seems like a very solid ruling to me that we need discovery here. Okay, so that's the big ticket item, the vindictive prosecution. Then we also have a whole separate motion to dismiss because Lindsay Halligan Comey alleges, was improperly appointed. And we've been through this with Alina Habba, and it's pretty labyrinthine. What I always try to say is the labyrinthine law and regs are there to prevent the administration from doing an end run around congressional ratification or role in choosing inferior officers, here a U.S. attorney. And you look at the scheme, and it basically says you can do an interim appointment for 120 days, but then the court will appoint, or until the administration can get someone confirmed, which they haven't been able to do or haven't managed to do in the Eastern District of Virginia, and I don't see they're doing soon. The administration's position is basically we can do a 120-day interim appointment and then another, and then another, and then another, or it may be 119-day. And that really mangles the statutory scheme, and it makes it clear if they could pull that gambit, then they could just have a series of interim appointments, and they would never have to go to the constitutional obligation of submitting that person to the Senate. So besides a strong argument on the actual, here's what this says A, not the, and the structure is X, not Y, the sorts of really fine-grained statutory interpretation arguments people make, Comey's got the general point that I think is really powerful of the administration's position means that the whole setup in the regs and law could just be easily gotten around by the administration, and that can't be what it means. And indeed, the Alina Habba case said the same thing, and other cases said the same thing. So, I think it's a pretty strong case, if an unusual one, and the real action may come on the question of remedy. So there's the whole, almost half the brief that's devoted to saying you need to dismiss it with prejudice, especially given how egregious the whole course of conduct was. And here they bring back in the stuff that from the other motion about how that this was a matter of political reprisal. Interestingly, there's no mention in the brief of the statute of limitations issue that, to my mind, if Nachmanoff dismisses, means the U.S. wouldn't be able to retry it. But they just, the proxy for that is you should dismiss it with prejudice because it was, she is a nullity so it was signed by someone whose name could just as well have been Yogi Bear. She's someone who just not qualified to be U.S. attorney. And so the indictment is void in the language of the law, which means it's, basically a null event. And so you dismiss with prejudice because there's nothing to support the charges at this point. That obviously they go at length, and that is shaping up to be a whole secondary fight on this Halligan motion. Though, as I say, I think, however it's dismissed, I don't see how the U.S. can revive it given the statute of limitations problem. Okay, so this second one, more arcane and technical, but seems pretty strong. Other courts have held the same way, and it would be an alternative route to just say the whole motion all gone, sort of never happened. Now, what wouldn't that do? Give a judgment of 12 persons, good and true. That would be the more definitive rebuke of what Trump has done here. Trump could be expected to just rail against Nachmanoff, the judge, as a liberal activist or whatever. But criminal defendant, looking at loss of liberty, even in a very, very remote possibility, you got to pull out you got to take all your good shots, and these are two good shots, even though they may mean that Comey is out of trouble without even having to present evidence. That, and any day for a criminal defendant, has to count as a good result. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.